Welcome to today's Explainer. Today, we're diving into a massive legal shakeup, a landmark 1961 judgment from the Privy Council, which was the absolute highest court of appeal back then. This judgment fundamentally changed the way the law views cause and effect. We're looking at a case famously known as the Wagon Mound, which was a showdown between the Overseas Tank Ship Company and Mortstock. And look, this isn't just some dry, dusty legal dispute. It's actually a really fascinating philosophical battle over how we define fairness, blame, and, well, the very limits of human foresight. Let's kick things off with a hypothetical question drawn straight from our source text. I want to get you thinking about the limits of your own moral and legal responsibility here. Imagine you make a tiny, totally forgivable mistake, a venial act of carelessness, as the judges actually put it. But through some bizarre, freak chain of events, that tiny mistake of yours leads to an absolute catastrophe. Now, should you be forced to pay for the entirety of that unpredictable disaster? Just keep that in the back of your mind as we go. To make this dense legal text crystal clear, here is our roadmap for today. 1. A careless mistake. 2. The rule in polemis. 3. The foreseeability test. And finally, 4. A new standard of justice. All right, let's jump right into part 1, a careless mistake. Let's look at the actual facts of the case. So here's the physical timeline of events, and it cleanly separates the initial tiny mistake from the crazy, improbable fire that happened later. Step 1, furnace oil is carelessly spilled from a vessel owned by Overseas Tank Ship. Step 2, that oil floats over and congeals on the slipways of Mortstock. Now this causes some minor, pretty insignificant damage, but then step 3 happens. Totally unexpectedly, that furnace oil floating on the surface of the cold seawater catches fire, and the resulting inferno causes massive, absolutely catastrophic destruction to the entire dock. Now, here's where it gets really interesting and honestly, kind of ironic. This is the critical finding of fact from the original trial judge. Obviously, furnace oil is meant to burn in a furnace, right? But based on expert testimony, the judge found that it was a known scientific belief at the time that this oil simply would not catch fire when spread thinly on cold water. The trial judge explicitly stated that the defendants could not reasonably be expected to have known this was even possible. It was basically a freak scientific anomaly. And yet, under the law at the time, the lower court still held the tank ship liable for the entire massive fire. So why did they do that? Well, that brings us to section 2, the rule in polemis, which is basically the ghost of the old law. So, way back in 1921, a case known as polemis set this massive legal precedent. In that case, some stevedores carelessly dropped a wooden board into a ship's hold. And incredibly, that single piece of wood caused a spark, ignited some petrol vapor, and boom, it destroyed the entire ship. The court ruled that even though destroying a whole ship was totally unforeseeable from just dropping a piece of wood, the charterers were still liable. Under this polemis rule, your liability was tied to a direct chain of physical events. It completely 100% ignored predictability. Reading directly from that older case law, this quote really spells it out perfectly. It says, if the defendant is guilty of negligence, he is responsible for all the consequences, whether reasonably foreseeable or not. And you see, this is exactly why the lower courts in our Wagon Mound case initially held the tank ship liable for that massive fire. Because the fire was a direct, physical result of the spilled oil, predictability just didn't matter. But when the Privy Council judges looked at this case in 1961, they realized this older rule was fundamentally totally broken. The Privy Council fiercely criticized this old rule. They argued that making someone pay for completely unpredictable consequences just because they were physically direct was incredibly harsh and totally illogical. They actually said it offended the common conscience of mankind. I mean, it punished slight venial carelessness with potentially infinite liability. Think about it. If you bump a table and it somehow triggers a freak earthquake, should you pay for the earthquake just because the physical chain of events is direct? Of course not. The judges knew they had to fix this. Let's move on to section 3, the foreseeability test. This is where the major legal pivot happens. To understand this, we need to clearly define culpability. In the past, older judges, like Lord Summer, tried to argue that what a reasonable person anticipates only goes to their culpability, basically whether they were at fault. But they claimed it had absolutely nothing to do with compensation, meaning how much money they actually have to pay. Well, the 1961 Privy Council judges completely rejected this idea. They argued you simply cannot separate the criteria for blameworthiness from the criteria for financial payout. Quoting Lord Sumner's old idea directly, the new judges boldly declare, Their lordships find themselves bound to state their view that this proposition is fundamentally false. Essentially, you can't say someone is only slightly culpable, but then turn around and make them compensate for an infinitely massive, unforeseeable disaster. The liability has to match the foreseeable fault. When we actually put these two paradigms side by side, you can really see what a massive shift this was. Under the old law, you're liable for all direct consequences, no matter how wild or unpredictable they are. But under the new law, established right here by the Wagon Mound, you are liable only for foreseeable consequences. It completely shifts the entire focus of the justice system away from the mechanics of physical cause and effect and places it squarely on the boundaries of human expectation. The core of this shift is captured perfectly in this devastatingly articulate quote from the judgment. After the event, even a fool is wise. I mean, it is just so easy to look backwards at a disaster and connect the dots, right? But the law cannot judge our everyday mistakes using the unfair advantage of hindsight. It must use the foresight of a reasonable person acting in that specific moment. The judges then use this fantastic rhetorical question to really drive the point home. Who knows or can be assumed to know all the processes of nature? Honestly, expecting a perfectly reasonable ship captain to predict every bizarre chemical reaction, like furnace oil catching fire on cold seawater, is simply absurd. We aren't omniscient, so the law definitely shouldn't treat us like we are. The text uses some really great physical imagery here, talking about a chain with missing links to explain why we absolutely have to limit liability. The judges point out that legal causation shouldn't rely on the scholastic theories or metaphysical controversies of philosophers endlessly arguing about what a cause truly is. Instead, they strip it right down to pure common sense. Foreseeability becomes the sole effective test. If a reasonable person couldn't see it coming, the chain of liability is broken. It's that simple. And that brings us to Section 4, a new standard of justice. Let's look at the resolution. Applying this brand new rule step by step to our original facts, the Privy Council resolved the whole case like this. Step 1. They applied the standard of the reasonable man to the ship's crew. Step 2. They noted the established scientific fact that the fire was totally unforeseeable. Step 3. Because it was unforeseeable, they broke the chain of liability. And finally, Step 4. They officially dismissed the negligence claim for the catastrophic fire damage. The ship owners were simply not liable for the millions in fire damage, all because they reasonably could not have predicted it. The ultimate takeaway of today's explainer is really summed up beautifully in this quote from the text. Civilized order requires the observance of a minimum standard of behavior. You see, the judges point out that demanding a person be responsible for things they cannot foresee is just too harsh of a rule. But, on the flip side, to demand less than what they can foresee ignores the basic rules of civilization. We have to hold people to a reasonable minimum standard of foresight, not an impossible standard of perfection. I want to leave you with one final provocative thought about the philosophy of justice to ponder long after this explainer is over. Does a just society punish the unforeseeable, or only what a reasonable mind can foresee? The Wagon Mound case decided that fairness lies in our ability to anticipate the future, protecting us from the endless, unforeseeable ripple effects of our smallest mistakes. Thank you so much for joining me on this deep dive into the source material. I hope you walk away today with a totally new perspective on how the law views cause, effect, and responsibility.